so we'll be done by 2 or before, because we're going a little bit faster today already. Good. So what we're going to do right now is Emily and I are going to go through the process. I think it's a good reminder to go through this. I know Chris has gone through these a couple times with me before, and there's sometimes some really good discussion that goes on, so it's some really helpful things. And so these PowerPoint presentations can be real helpful. And it's nice hearing Paul's voice on the line as well. I kind of consider him the founding father of the Naturalization Day program, having started it, about 6 years ago now, right? Is that it, Mari? I think we said 6.
I think it's 6,
last
yeah.
thing. So let's look at slide number 7, the basic naturalization eligibility requirements. These are the things that we're really looking at. We all know, we had, like I said, the paralegals and other volunteers in on Tuesday, and and there's been some press in the last couple of days about illegal immigrants in Washington State and the number and things like that. Remember, we're going to be dealing with people who are permanent residents. These are the people who are going to be applying. So, and we have the basic standards. There's no reason to be talking to someone if they don't meet those basic standards. 18 years old, they have the residency issues, the physical presence requirements, good moral character, which is the challenge, I think one of the more complicated ones at times. Speed read and write English, lots of discussions this year. There's going to be this good screening that's going to make sure that people who are going through this process are really going to be able to go through and to the end for naturalization. So the screeners really help a lot. The knowledge of U.S. history and civics, and willing to take the oath of allegiance. Now, just those points alone looks nice and easy. For those of you who haven't done this before, and we mentioned that we're not having PERS bands and things like that. If you have a particular resource book that you like, bring it along with you. Make sure you take it when you leave. Make sure your name's in it. It might be borrowed around. One America provides, or WNA provides, lots and lots of resources there. There will be tables of handout materials. And so when you arrive at 9, use that time to get around there and see what else is there, because invariably you're going to talk to someone who's going to have a need for at least something on the handout tables. And now we start the tag team. Ready? Go! Okay.
So this is Emily Headings now. I'll first talk about the residence requirement, and there's various parts to this requirement. First of all, the applicant needs to be a lawful permanent resident. Okay. We'll talk and do PowerPoint at the same time.
We can do it this way now.
Okay. An applicant needs to be a lawful permanent resident or green card holder for at least 5 years, and that requirement is lessened to 3 years if the person is married to a U.S. citizen and has been married to that citizen for 3 years and is still living in marital union with that person at the time of filing the application. If they would separate from their spouse, they could still potentially be eligible as long as they're still with them at the time of filing and still legally married to them at the time of their interview and oath ceremony. Obviously on the green card, that's where their LPR date is listed. There's a special rollback rule for people who came as refugees or asylees. Refugees' LPR date is the date of their entry, even though they don't apply to adjust status until a year after they've been in the country, but their date should be rolled back to their entry dates. There might be a little confusion about that if you're talking to someone who came as a refugee. And then asylees also benefit from an earlier LPR date. Their date is backdated to a year before their adjustment application is actually approved.
And Emily, would that be shown on the card though itself?
No, the rollback date, yes,
Yeah.
would be shown on the card, yeah. But there might be some confusion if you say, oh, when did you come? And it's the same date as on their green card. That could lead to some confusion if you're not aware of that rule. Do you want to take the next part of the residency rule?
Right, number 2, this is slide number 9, residence requirements number 2. The residence has to be continuous. A lot of people ask, what do you mean I have to stay here every single day? And it's not continuous residence in that regard, but it's that there's not a period of time during which you've been gone so long at one time that you actually break the continuity of residence. And so before people get to you, probably even if you're one of the early ones and just taking people and filling out the forms yourselves, there are sheets for people to be able to put all this information together. You won't be just starting to figure out a person's time in the United States when they get to your table. You'll be able to look, and for absences that are 6 months or less, not a problem. They're there. You're able to consider that. But an absence of greater than 6 months to less than a year, that's the issue. You're going to start asking a little bit about, well, first of all, the fact, I always think, Emily, the fact that they're there in front of you is probably pretty good. But you want to do things like, you know, what were your plans when you left? Did you have a return trip ticket? Did you keep bank accounts in the United States? Did you do those kind of things that help evidence that the person's their intent was to reside in the United States even when they left? Absences of 1 year or more, pretty darn serious issues. You might want to even be conferring with other attorneys as well, because there might be an issue of, in my mind, whether they are truly a lawful permanent resident or not. Even though they have the card, even though they're physically in front of you in the United States, that person might have some issues about whether to apply or not. So that's the continuity of residence issue.
I have a quick question about that.
Yeah, question here.
If it turns out that they have broken the continuity of their residence, would they have to readjust then? Or is there anything that they can do? Say it was like 10 years ago and
So
they've been living here since.
the question is, what if there was that extensive break? Let's say a year and a couple days or a year and a half or something like that. Does that completely wipe them out of being able to apply for naturalization? I haven't dealt with that situation. I think Emily has, so I'll have to answer.
Yeah, so if the absence is a year or longer, it's an automatic break in continuous residence, but that doesn't mean they're no longer residents. It just means for naturalization purposes, their residence is broken, and they need to start accruing that 5 years again from the date they returned. But the key is you only need to be here 4 years and 1 day, because you have that 364-day window that can be just traveling abroad without automatically breaking. So, yeah, you want to make sure then that they've accrued that 4 years and 1 day since their return date. Now, if they did have a super long absence some time ago, at least the local office has I'm getting a little bit ahead of myself. Let's go into the next slide.
And I'll jump in here too. If you're dealing with a person who's using the 3-year standard, it's 2 years in a day that they have to have been back to be able to do that. Chris has a comment.
I just want to say, just when thinking about this, think of two things. One is it a problem for naturalization purposes? So if your first part of the analysis, is it going to be a problem for naturalization purposes? If it is, well, is it also a problem for abandonment? You also have that issue.
Okay. Yeah, that's a good point. Chris was just pointing out that there's sort of a dual analysis you're doing here, and the first is that continuous residence for naturalization, which we were just talking about. And then the second point is a removal issue, which is on slide number 10. Long absences may also be a flag for the person having abandoned their residency, which I think maybe Elizabeth was sort of getting at too. But those are kind of separate analysis. The continuous residence I look at as more an objective analysis. Is the person actually keeping their home here? Is this their place of general abode? And is there objective evidence of that? Is there a lease or a mortgage payment or family living here, kids in school, a job they came back to, that kind of objective thing? Whereas the abandonment issue is more of a subjective issue. What was their intent when they went abroad? Were they intending to go live in India or wherever for 6 months or a year or 3 years? Or were they just going to take care of a sick relative, and it just turned out that they had to stay that long to care for them? You want to do kind of the separate analysis when you're looking at absences, and even absences over 6 months could be a flag for abandonment if the intent of the person when they left was to move to Canada or wherever. So you might have to do quite a bit of talking with that person about the trip and the purpose of the trip, and what kind of objective proof there is that they actually maintained a home here in the United States. So, any questions about that?
One thing I think to think about too, if you've got a person who has that lengthy absence, ask if they had a reentry permit. Did they apply for it, have a reentry permit issued, or some people call it the white passport, something like that, because that could be a really easy explanation for why you had that period of time.
Emily, were you going to say something about the local office?
Oh, yeah, I was, sorry. It seems like the longer ago a long absence was, the more likely, the local office at least, will look at it as The time accrued shows that your intent was to live here, meaning that, so if you have a 2-year absence 15 years ago, the fact that you returned here and continue to live here for 15 years since then kind of goes to showing your subjective intent to be residing in the United States and not abandoning your residency.
What they put on their application for a reentry permit can also be very damaging, so, you know, it can indicate intent that they're telling you wasn't there or whatever, so intent to abandon. They don't think, like, I've got a job in India.
So someone here is pointing out that the information you put on your application for a reentry permit can be problematic when it comes to explaining your intent.
You wanna
for
know what it is.
going overseas, and I guess to get that, you probably need to do a FOIA,
Unless they.
right? Or
have a
ask them
copy.
if they remember. I mean, that's always
Fair
kind of
enough.
tricky, yeah.
Yeah, and we all know how reassuring it is to knowing that the local practice, according to the people you talk to, is to generally do something. It's like, yeah, but I need something solid. I've talked to people at headquarters sometimes about that, and one of the issues that I heard kind of quietly, just, you know, there's a kind of a standard of if the person's had this great lengthy absence and now come back at least twice, that absence is really essentially a non-issue as far as the government is concerned. Again, my position is, could I see that in writing? I said, nothing, you're not gonna get anything there. All right, let's go to the next slide, which is number 11, residence requirements number 4. One of the rules, this is where we start getting into these kind of interesting things. The person is supposed to be resident in the CS district area or the state where they file the N-400 for at least 3 months before the date they file. There is this ability to file 90 days in advance of that, and Emily says one of the great kind of thoughts is if a person shows up and says, yeah, I just moved here today, and you're talking to them, probably, and they say, and I plan to live here for the next forever, probably still a pretty good idea to say, why don't you just hold off for a little bit? And this is due to the issue of the Immigration Service sometimes getting fast in their naturalization decision, interview scheduling, and if they got it scheduled for an interview that occurred less than 90 days from then, there might be a problem, and there was actually a couple years ago when they were going really fast. So that person might be a good idea, even though you're filing before you've hit 90 days, wait a little bit before you file it. Must reside in the United States from the date of filing from filing of application, let's see, from filing to application, filing application to oath. Some people get the feeling, they kind of say, well, now that I file this, can I leave at all? And yes, they can leave at all. They just, again, can't break their continuity of residence. That's the big issue. But they can travel. The big thing I talk to them about is make sure someone's checking your mail, because you'll get a fingerprint notice, you'll get an interview appointment notice, and you don't want to miss that. So yes, they can be gone for a while, but have someone there. And now, on the thing about may apply 3 months before residence, I mentioned that briefly, and just one thing, if you haven't done it, if you've got a person who's applying based on the marriage, you're 3 years married to a U.S. citizen as a permanent resident, don't let them file earlier than the completion of their 3 years married to a U.S. citizen as a permanent resident. You can't file before that. You can file, up to 90 days before meeting the 5-year issue, or 3 years, conceptually, but you have to have been married to a U.S. citizen for 3 full years as of the day you file as a permanent resident. If you file earlier than that, you've got a problem with it, so just watch that timing there. And sometimes people say, well, how would that possibly happen? Well, a person might be a permanent resident and 8 months later get married and be married to a U.S. citizen for 3 full years and be a permanent resident for 3.5 or 4 years, and that's where this kind of weird timing comes into play. All right, next slide.
Okay.
Oh, let me go back one.
Karen? Yeah.
The box, well, I don't, whether you check 3 years or 5 years,
Yep.
It's really important to, well, it might, if a person's been here 8 years as an LPR and they're married to a U.S. citizen, well, I don't know, it might be better to check the 5-year box, because if something happens to the marriage, or they don't really tell you, but the guy, the spouse isn't there a lot of times, or there's the marriage is troubled, it can cause an enormous amount of trouble for the applicant, who might be put into investigation for marriage fraud, because they checked the 3-year box.
So a really good point. If you've got a person who basically qualifies for both, and you don't have any other issues in terms of good moral character or things like that, there can be a benefit to using the 5-year issue as opposed to the marriage issue. For one thing, it's less documentation, less to have to prove.
Right.
I've got a client like that right now who's been a permanent resident for 30-some years, and he just said, and he's married now to a U.S. citizen, and he just said, file based on me being a permanent resident for 5 years, and that can just avoid some of the issues that you have. I'm sorry, you've probably heard this, but make sure people here, in terms of maybe the marriage might have a problem between the date of filing and the date of the interview, or maybe they don't live together very much, they don't see each other very much, things like that.
All right, the next requirement on slide number 12 is the physical presence requirement, and that is separate from the residence requirement. This just refers to the number of days the person was physically inside the borders of the United States, and the requirement is that they be here for half of the 5 years, if applying under the usual rule, or half of the 3 years, if married to a U.S. citizen. And this can come up separately from the continuous residence rule if, for example, the person would have a large number of short trips, to Canada or Mexico or wherever, and you might need to start counting up the days and making sure they have the physical presence requirement at the time of filing, not by the time the interview comes around.
I'm going to throw in one on the 90 days residence in the district, because I actually had one that was referred up from people lived in Portland, and then they decided to move up here, and the attorney was handling it, said, well, they want somebody to go in with the interview. The filings were done with driver's licenses showing an Oregon address, and the officer, who just decided to be very officious, was like, well, this is an Oregon address and Oregon tax documents and stuff, and I need to see evidence that you've been in Washington and all that. So it's helpful to consider what other evidence a person has of actually residing in that district. Someone's moving some things around by their phone, so just kind of watch that noise around there. Chris?
Can you just quickly review the rules on counting those days of physical presence? For example, you're in Canada for 3 hours and come back.
So you only need to count absences of 24 hours or greater as a day. So if you just went for the day, you don't need to list that on your application for one thing, but also it doesn't need to be counted for purposes of counting days of physical presence. So any hour you spend in the United States counts as a day, as that day.
Which is a completely different way that CBP looks at it for all sorts of other issues, so it is kind of confusing.
Yeah.
And you actually gave the number of days that half meets.
I didn't have them written down.
I have it written down here, so I'll let you give it
Good.
there, because you gave it to me. You were the one who did it.
So half of the 5
Yeah, that's 30 months or 5 years.
is 912 and a half days, and half of the 18 months or a year and a half is 547 and a half days. And I actually had officers in the interview calculating it up. They have a program there, so you want to do that too.
Yeah, you actually will, in your attorney binders will have calendars that go back, so you can actually count the days on that.
So-
Okay, you did from the other.
I have a question. So it's not, if somebody takes a trip, they leave one day and return the next. The program I have counts, say, maybe it's not the day they return, but the day they left, but they don't, well, on the calculators, you can, I don't know how to say this.
We
you're
count one of those travel
Yes,
days,
you
you're
count
saying.
one of the trip days. Is that correct?
Oh, well, my understanding is if you're in the United States on that day, you don't count it as a day outside of the United
Really?
States. Yeah. So even if you're gone, let's see, a period of 24 hours, but it's 2 different days, you were still in the United States each of those days. So you don't need to count it.
No, let's say you go to Europe and you leave on a Monday, on January 1 and you come back January 10. You count one of those days as out, but not both. Is that?
My understanding, and here's where we have some interesting discussions,
Okay.
and you will probably find, if you don't do it this weekend, sometime in your career, someone's gonna show up and say, I wanna file Monday, and you're like, well, wait, you're like right on the edge. That if you left on January 1st at 10 o'clock in the morning, you will have been considered here on January 1st.
And if you come back before midnight?
Well, so now I'm
Okay.
trip to Europe. Now you come back January 10th at 2 o'clock in the afternoon. That's still a day in the United States
Okay,
for
great.
counting purposes here.
Oh.
Now, for recapture of days in CBP language, that could be a different issue. They look at it differently. And those of you who deal with Canadian snowbirds, there's a big uproar going on right now how they count their days. So these are different kind of things. So, and yes, I just calculated my 112 now. But yeah, I think the thing to remember, if you haven't dealt with it before, is it's kind of scary when you have someone who's just right on the edge and says, no, this is when you have to file, I need to file it now because I'm gonna leave the next day or something like that. And I've had people who I was listening right on the edge, whether this would be approved or not. All right, let's move on to slide number 13, good moral character. A person does have to prove good moral character during the window of time, either that 3 or 5 year period of time we're talking about, and that's why it's really helpful. If you have a person who has an issue at 4 years or so, and they qualify to file at 3 years based on their marriage, you may really want to file based on the marriage, because you push out that good moral character issue if it's a discretionary issue. And that then leads to the next thing. There are statutory bars where and we're gonna go into some details here, but there are ones that say, it happens in there, you cannot naturalize. And there are other ones where if it happened during that period of time, you're gonna take some risks. It's gonna be a discretionary issue, and you're going to want your person to have pretty good evidence to show why naturalization should be approved. Karen?
So I have a question about counting the 3 years or the 5 years. If the person was on probation and the probation ended, do you start counting after the probation's ended? That's one question. The other question is, I know the date of the offense is critical, so which do you, or are those two different issues?
So a person can be on probation during that statutory 5 or 3 year period
As long
without
as
it being
they're
a
off.
problem, as long as they're off by the time their interview and
Right.
oath come along.
Okay.
And the second thing you asked about, the date of the offense, not the
Yes.
date of the conviction or any, subsequent court proceedings is what's key. So it's the date of the violation, not the date of, and we'll get more into that detail in a little bit when we kind of delve more into good moral character. But yeah, I've had many clients who've been on probation, almost up to the filing date, and and that's not a problem.
Sorry, did you say they have to be off probation by the filing date or the interview date?
By the interview date, yeah.
Sorry.
Or by naturalization, actually, which is often the date of the interview in this district, so. Yeah. All right, so let's move on to slide 14, which is the requirement having to do with English language. And there's 3 parts to the English language requirements: speaking, reading, and writing. And the officer judges the person's speaking ability by their ability at the interview to answer questions about the N400 application. And arguably, the information that they're talking about on the application goes well beyond basic English or 4th grade English, which is what the level that's required, more or less. So they'll determine that by answering questions, and then at the end, they will have to show that they can read and write 1 or 2 basic sentences, and of course, they're provided with the vocabulary that's often required for those reading and writing, and it often has to do with the civics information too, so that's all kind of interconnected. There's a couple of exemptions for the English language requirement. One, and they're generally based on the person's age and their length of residency. We call them the 50-20 and the 55-15 rules. If you're 50 years or older at the time of filing and have lived here as a permanent resident for at least 20 years, you can use an interpreter at your interview. Note that you still have to take the history test with the use of an interpreter. Similarly, if you're at least 55 years old or older and have been an LPR for 15 years, you can be exempt from the English language requirement. And then for individuals who are 65 or older and have lived here 20 years as a resident, You also can use an interpreter, and I guess this is getting into the history part, but we have listed here that you only need to study 20 of the 100 questions and answer those during your interview. Finally, there's also something called a disability waiver that is for individuals who have a medically determinable disability or condition that prevents them from learning or remembering or showing knowledge of English and U.S. history. And this requires a separate form, the N648, which is completed by a doctor or a psychologist who says that the person's condition prevents them from reading and writing. And that's a form that's submitted with the N400, so that's obviously something we won't be doing on Citizenship Day.
Marie, did you say that the age issue, that's at the time of filing,
At the
right?
time of filing, yeah, not at the time of, because I've actually had a client that was dinged on that before I keyed in that, yeah.
There are some agencies, and I think we have referral information at the site, there are some local agencies that can assist with the disability
Disability waivers, that's
and
right.
we'll refer them to that.
Yeah,
Things like
yeah.
that.
Northwest Immigrant Rights, someone was mentioning that there are agencies that help with the disability waiver, and that's right, and they'll be on the referral list. NERC does a ton of those, and other community organizations do that too, so.
Yes, there'll be that, and then also there'll be, we have the history and civics and all the questions available as well in different languages, and the 20 study questions instead of the 100 as well, so.
And I think as a practical matter, if you're exempt from the English and you don't have to write the sentence, because you may have people coming in there who are illiterate in the sense that they can't read or write, but are capable of learning the civics questions. So-
Right, so it is possible to get a waiver of just the English, but not the civics, you're right, it could be either or both, yeah. Karen, did you have a question?
Oh, what was it, if it's a disability waiver or one of the top 3, you can get a waiver?
So the top 3, we call them exemptions, like you're exempt from the English requirement if you meet those residency
Right.
and age requirements, and then the disability waiver is separate, it's unrelated
but
to
the-
age or
But the
residency.
last statement you just made applies to the
He said someone who is illiterate,
Yeah.
who says they can't read English, they will never learn that, but, so is there an exemption that they can get from the reading, writing?
So, yeah, if someone's illiterate, that doesn't fall under the disability waivers,
Right.
that's not a medical condition.
So you're saying they may waive reading,
Well, so if you get the English exemption
Yes.
because of your age and residence,
right?
you don't have to do the reading and writing, because that's included in the English exemption. So if you meet the exemption and you happen to be illiterate, that's,
Okay.
is that okay?
That's good. But then the test will be in your native language, and then you're just orally giving
It's
the
an
answer to
oral
that,
test,
so.
yeah. The history
So you
test is
read and
oral.
write 1 or 2 basic sentences in Spanish?
No,
Oh.
there's no literacy test
Okay.
for naturalization. It's an English test, and it consists of
Okay.
reading, writing, speaking. But if you're exempt from English, you don't have to
Okay,
show
I'm sorry.
knowledge of any of
It's
that.
kind of weird.
Is there any exemption if you are literate and you don't meet the English exemptions?
No. I mean, it might happen that if you are illiterate, you might have a disability that exempts you,
Mhm.
like you have dementia, or you've had a stroke, or you have PTSD, or, I mean, there are, yeah, you can sometimes find a medical condition that also exempts you, and that's helpful, but.
Or you tell a person to wait a while,
And,
meet
yeah,
one of the
study-
exemptions. and-
Study, yeah, that's true, you can.
So you may be planning to cover this, but I just thought of it as I'm looking at this slide. Are we supposed to ask people whether they have pending petitions for family members that depend on their remaining an LPR? That would change the quota if they become a citizen? We're not worrying about that.
Chris, I don't think we've ever.
Mexicans.
No, that's a
Yeah.
good question.
Because it's
Yeah,
a big
it is a
issue
good
with
question.
Mexicans.
The question was whether we ask whether they have any petitions that depend on that person being a permanent resident for their priority date issues, things
Yes,
like that. So-
and it's a big issue
Yeah.
with Mexicans, that's why I'm asking, and it's a really hard thing to
That's a
screen
great-
for, but it is an issue, I think probably should be asked.
Marie is writing things down crazily. That's a really good one, and I don't think we've ever discussed it in
Really?
the thing, so.
I don't know, well, what do you think?
Yeah.
No, I think it's legitimate.
Yeah.
Yeah.
And we're, like in Mount Vernon, are there gonna be a lot of Mexican
probably that's a
Immigrants,
heavy,
yeah. That's what, you know, I'm
We might have to prepare something that we can stick on the screen form or something.
So we're thinking on the fly here, folks, on the telephone, we're trying to see if we can come up with something to help us deal with the potential issue
No,
of
no,
just
it's
got
good.
identified, depending on their retaining permanent residence as opposed to changing everything if they naturalize, so, good question.
Do we happen to know what the difference in ladies are now?
Well,
You?
is it just you?
Well, for unmarried, I was just
Some
looking
people
at
bounce
some
back
kind
though,
of
like
they,
married. I don't know, I'm dealing with it now.
the children of US citizens is
I've seen a couple where I said don't naturalize.
I know unmarried.
I can go get
So we're gonna keep going
Yeah,
with the.
actually unmarried sons and daughters,
Yeah, we're just
or
gonna work
unmarried
through this
children
issue
of
here. I'm gonna
LPRs
move
is
over to slide number
2005
15
April.
for you on the.
Married sons and daughters of LPRs.
There's a little conversation going on here though on that issue.
1992, and it's about a year
It's very
difference right now.
important.
So-
You know, in 6 years of doing, I don't know if Paul's still online. How
But a
about
big
Paul? 6 years
difference
of
for
doing all this stuff and we're all
children.
like, hey.
Unmarried
yeah,
children.
yeah.
So that
Lots
would
and
be
lots
the
of
one
changes
that's
have occurred in the course of 6 years. This has got to become really a much
Yeah.
more formal program with all sorts of, well, that flow chart alone is one thing where you get a sense of how much has gone into
Are
this.
they already LPRs, are they eligible?
We have the visible
You know,
one in the binder.
Yep.
And
No, they,
everything will
oh,
In other words,
update one.
if they have children that are of the age that would be eligible to be LPRs, but they're not yet, right?
So Chris,
They're not gonna automatically get citizenship when the parents get it, so it complicates
the
the
age.
calculus,
Oh.
a
I know, this.
little bit. Yeah, we'll have to sit
Yeah.
down and sort of.
Figure out a
sift
way
through
to
that for next time. yeah.
truck through it. So, okay, we're gonna move on just because everybody, has time and stuff. US history and civics, so, if you haven't, first of all, we're gonna have, you must answer 6 out of 10 questions is the standard for people, 6 out of 10 questions. If you haven't done it, look at the 100 questions, and, we have the 100 questions there. I think we have them in different languages too, don't we? Yeah. Because some people may be tested in their native language or language of their choice. So you can get those 100 questions, it's pretty cool, look at it, see what the answers are. They aren't the same questions and answers that they used to be, so we changed them a bit. If you haven't sat through a naturalization interview, the interesting thing is, you wonder, how do they come up with the 6 questions? Do they kind of pick and choose? I thought the officer got to do that, maybe back when I did that, they did. But now you can see, you can watch them, and you realize exactly when that comes up on the screen. Suddenly there's questions there that say, their head kind of moves back, and they don't have any choice. These are the questions that just kind of came through the system. As we've said, English exempt people still have to pass the the history and civics test. There is an exemption from that as well in a sense. 65 years and at least 20 years as a permanent resident, you're exempted from the English and tested in your native language. And it's a limited number. And they tell you which number. You get 20 questions. There are 20 questions. Those are the questions from which the 6 of 10 will be asked. So it's much less to have to know in terms of history and civics. It makes it a lot easier to deal with, a little less daunting. And again, we want to remind you about the disability waiver as an option for people on this issue.
All right, so the last requirement is that the person needs to be willing to take an oath of allegiance to the United States. The oath is printed on page 10 of the N400, so I always like to go over that with the person before they sign it, just so they know what they're going to be agreeing to. And it has a lot of fancy, flowery language, so it's great to simplify that for them, especially for people with limited English. And it does include being willing to bear arms, even, elderly women or whoever you might be looking at, they have to be willing to bear arms on behalf of the United States. And if they are prevented from doing that because of religious belief, they can request a modified oath. And so they would not mark yes to 2 of those questions in the list of oath questions at the end of the form. And they would bring a letter from their religious leader attesting to the fact that they belong to a religious organization that doesn't believe in bearing arms. So they could just take that letter to the interview. And that probably wouldn't be a reason to refer a case out if you can explain that to the person on Citizenship Day and be assured they're going to get that letter.
All right, now we move into the statutory bars, good moral character. I guess it's not statutory bar to good moral character. It's regarding, isn't it?
To showing good
Yeah,
moral
to
character,
show.
I guess.
So they can be permanent and temporary bars. The permanent permanent ones. This is where, because the issues about criminal issues, I always say there are people in the room who are way better at this than me. We're gonna have a person either directly in the room or accessible by telephone who'll be able to deal with this issue. I expect that if you're dealing with this kind of issue in terms of a really serious one, that person will have already been to speak with the criminal defense attorney and gone through the process, and so you're getting some information already done. Marie, did you have, Marie?
No, yeah, I mean, we'll have at least one, if not more people at each site.
Okay. Permanent bars, we dealt with ag felony under immigration terminology. Ag felony conviction after November 29th, 1990 sets that bright line. That's when the person is permanently barred from naturalizing. Conviction for murder. I've been fortunate. I've never had a murderer sit across the table from me and tell me that, and have to say, "Gee, you can't naturalize him. Would you please, really? Would you please leave the room quickly?" I don't know. But those are the permanent bars. Emily?
Okay. All right, so now we're gonna get into some other bars to good moral character, and we call them temporary bars because once they've moved out of the 5 or 3 year statutory period, they're no longer a bar to showing good moral character, although we still need to be mindful of how any of these activities or conduct could make the person potentially removable. But right now, let's just talk about the good moral character. And I'll just kind of tick through these and just try to give a little more information on each of them. So, and these come straight from 101F, INA 101F, and from, in the regs, I think it's 316.10. So, and one of the reasons this good moral character requirement is so, such a complex area is that the INA doesn't tell us what is good moral character, but it does list things that are not good moral character. And then there's sort of this catch-all category. And so it could include just a huge number of activities or behaviors. But going through this list, so if someone has been convicted or admitted to a crime involving moral turpitude during the 5 or 3 year period, then they're barred from showing good moral character for purposes of citizenship until that act has moved out of the 5 year period or the 3 year period. And like Greg was mentioning, hopefully the person doing the criminal analysis will catch these before they get to you. But and just a note about an admission, an admission can be done even if the person was not convicted. So again, that's something the criminal attorney will catch, but just keeping that in mind, that it doesn't necessarily mean that the person was found guilty of a particular crime. Second one, committed 2 or more offenses and had a sentence of 5 years or more. Again, that should be caught by the criminal attorney. Controlled substance violations. Again, there should be criminal documents about that, although not always. If you ask someone about drug use and they say yes, you want to delve into that a bit more. If someone's been convicted and spent 180 days or more in jail during the statutory period, that's a bar to showing good moral character. If they've been involved in prostitution or other commercialized vice, that's a problem. Prostitution is a sort of a term of art in immigration in that it refers to the prostitute or the person who procures prostitutes, the pimp, generally not the customer. So, what's that? Yes. If the person's been involved with prostitution in the last 5 years, that is a bar. Alien smuggling, as many of you know, that's a pretty broad term. It can mean something as minor as sending money to someone who's coming into the United States. So you want to really ask questions about that so they don't get caught in the interview admitting something that could be problematic. Polygamy, this doesn't refer to bigamy or not knowing you were married to someone else when you married a second person, but polygamy is coming to the U.S. to practice polygamy and have multiple spouses. And again, as you might recognize, a lot of these grounds refer to the inadmissibility grounds in 212A or 212, so they'll be familiar to some of you. Habitual drunkard is, there's one case on that, I think, that talks about it being akin to a chronic alcoholic. You should ask more questions if the person has a lot of DUIs or public intoxication issues in their history. So you want to make sure that, you know, their last 5 years, it doesn't appear that they have drinking problems. Then there's illegal gambling and having given false testimony to obtain an immigration benefit. And this is, you know, fairly specific. It needs to be oral testimony taken under oath with the purpose of getting an immigration benefit. So all those factors have to be there for it to be a bar to showing good moral character during the statutory period.
Temporary bars, we are at, oops, excuse me, I'm sorry. Slide number 19, discretionary bars to good moral character. This is where if a person is insistent that they're going to file, they want to file during this period of time, there's nothing necessarily wrong with it, but you want to be sure that they have the evidence that's going to be able to overcome the concern about the good moral character issue. Child support is a really big one because they do have to deal with tax returns, and they're saying, and one of the questions, do you have children? They ask questions about whether you're supporting children. I believe that last year, at about the time we were doing these, we had it pretty well clarified that if a person's on a payment plan with the Internal Revenue Service where they're paying back taxes, where they're on child support and they've kind of caught up or on a payment plan, that can be acceptable. But you certainly want to provide that information to show that the bad thing is being corrected, and there's a regimented process that's going on there. Extramarital affairs, I was telling Emily that I had one a couple of years ago in a case that I was working on for a permanent resident who decided to have an extramarital affair with somebody, a U.S. citizen. The citizen's spouse wrote to the Immigration Service and said, this permanent resident is having an affair with my wife. And so we just said, there's going to be an issue here if you decide to apply for naturalization during the period of time, so it can be an issue. Selective service registration, we're going to talk about that in a bit. 18 through 25 are the age period that men have to register for the selective service. We're going to have at the each location a place where people can actually do registration. They can actually check to see if they're registered. And we also have the draft affidavits for people to complete if they're going to file saying that they didn't know or intentionally not register. Tax violations I mentioned briefly. Even crimes outside the statutory period, I mean, you always want to just kind of deal with it. What's there and why? I mean, you'd rather provide evidence to show that there's been not just a long time of being a good person, but maybe some information to show how they feel they've changed, so that they're, the Immigration Service shouldn't have to worry about that. Incorrect or false information on the N-400 or at the interview. Here's a point that I think is important, especially those of you who haven't volunteered before. You're going to be going in a situation where you've not done your work before. There are lots of people walking around, lots of people talking, family members sitting there, people asking questions, and I'd like you to try to pay attention to what's happening, because frequently someone will come in tow with a couple family members or friends, and this is an important day for them. And so they come in, and these people kind of all shuffle through together. And so they come and sit in front of you as a group. And if the paralegal hasn't been paying attention and thinking about this, if you haven't been paying attention and thinking about it, things like, how many children do you have? And I don't just mean children in your marriage. Any children from an extramarital affair? How about criminal activities? Why don't you tell me about criminal activities? Well, someone's not going to be too willing to say that stuff in front of a friend that they hadn't realized they were going to be asked all these very personal questions. So you want to make sure that you're taking time to get people separated if you feel that's appropriate. But whatever you do, that the information you're getting is real information. It's honest information. It's not filtered so that the people who are there listening hear what they think they know. You need to get the real information. So Karen, you're kind of...
So we're not just talking to one person at a time.
I think that's how we, and I'm going to look around to the people who have done this before, I think that's how we want it to be.
Yeah, oftentimes the couples will want to be there together, and you just have to sort of play it by ear. You have to sort of figure out and explain to them maybe like, look, I'm going to ask you some very personal questions which you may or may not want to have, and answer in front of your spouse, you wanna, think about it and, very quickly.
So I'm gonna just repeat what Chris has said, and this is the experience that I've had too. And the reason I said it, this is outside your normal experience. It just kind of happens, and you might find yourself sitting there and suddenly realize, wow, I'm talking to somebody else, and I don't even know who this is, this other person. And so I do things like, hey, I'd like to get some water. Could you go get me some water? And then you use that time to privately talk to the individual and say, we're going to talk about some things that are really private and personal. I want to make sure that you understand these things. It's absolutely critical. You cannot provide wrong information here. And so when this person comes back, I'm going to be happy to say to them, oh, by the way, we're just going to have a little conversation for a while. Why don't you sit over there? Karen, nothing wrong at all with as two people walk up sit in front of you saying, you know what, which one's the client for today? I'd like to talk to you. Could you, the other person, leave? Or why don't you take the kids over there and do something else? That's probably the better way to do it. I just have a feeling you'll find yourself at one point saying like, wow, there are 3 people here, what's happening? So try to remember that kind of thing. Illegal voting, it's been a couple years now since there was a real push to have the 18-year-olds vote or register to vote, so we haven't had that problem too much. Other unlawful acts. Again, just watch for these things and be able to explain them. Usually like the unlawful, like kids who were seniors in high school and one of the last big elections, there was a big push for it. They might have signed up to register to vote without realizing their permanent residence, they can't do it. And those can usually be explained pretty well. I don't know about voting, I haven't had anybody actually vote, but it's something to watch for.
And just to add on that note of voting and holding yourself out as a U.S. citizen, there's a really good memo from 2002 that talks about that issue and when it can be kind of excused. And there are circumstances where it can be, and I've had cases like that where it has been excused either because they sort of doing it without knowing what they were doing or being pressured to do it by someone at the DMV or something. So there is a way to get around those, but you probably wouldn't, we probably wouldn't want to assist people with those issues on Nats Day. We probably need attorney representation. All right, so slide number 20, just a couple of tips about good moral character issues. When you're looking at specific conduct, you're looking at the date of the bad act, not the date of the court proceedings that follow, as we had mentioned earlier. Also, if it's possible for them to apply under the 3-year rule instead of the 5-year rule, as Greg had mentioned before, just to get that act moved out of the statutory period, that's always good. And I believe everyone who's coming has been told that if they have any kind of criminal matters, they're to bring certified copies of all the court records so that we can make an analysis of that and recommend, or give them our recommendations about whether or not it's a good idea to file.
Okay, we're doing pretty well on our timing here, so I just want to let you know it's about 1:40 and we're doing all right, Chris.
I've had a case where the crimes were basically, and there were a few of them, were like 16 or 17 years ago, but he spent time in jail, in detention, a lot of time in detention within the past 3 years because he was being put in removal proceedings because of those old crimes. And so we did get the case dismissed and all that, so we have all that. In a situation like that, it looks like we would probably want to have the whole, at least a summary of the immigration court case history as well.
Yeah.
As the certified copies of the old criminal.
Yes.
Can you just repeat that real quick?
Oh, so the question here was, if someone's been in removal proceedings within the last 5 years, do we want to get copies of that type of paperwork? And I would say yes. When I've had clients like that, I always want to, you assume it's going to be there in the file that the immigration officer has, but it's always a good idea to bring in copies of the relevant documents, the termination order or whatever, the order granting relief, so that, you can show, yes, my client's still in LPR. And, I had one recently, just a week or so ago, where she actually did have the whole file there, and I didn't have to submit any of the criminal records or anything that I had because she had them there in the removal file, but I would just go in prepared with all the criminal records and the removal records.
So I think we're at slide number 21. derivative citizenship, is that where everybody is on the things? Okay. Somehow mine is a little out of order.
Oh, I have one question on the last slide,
Karen?
sorry.
Another question?
It said, do not submit sealed police reports. What's the policy on police reports?
What's the policy on police reports?
Our policy.
Our policy. I'm looking at Chris, but I think our policy is we don't like submitting no
Sealed.
problem submitting sealed reports, but we wanna see our own copy of what's in those reports so we know what it is we're submitting.
But we do submit police, I mean, I tend to
Yeah.
never submit police reports if I can help it.
Police, okay, so Chris, do you have a?
Well, I think, first of all, you wanna talk to the criminal attorney, but I think the issue there is, because you don't wanna have issues raised from the police reports, but as long as it's showing, explaining, if somebody was arrested, but this explains the circumstances and it shows that it was a fairly harmless situation, I think that's fine, but you won't know that unless it's unsealed, so, if you have a sealed one, but you have an open copy that they've given you separately, maybe that's okay, but I would be very careful there and make sure that, the experienced criminal lawyer has vetted it very carefully, and if they also aren't comfortable with making that decision, then refer them out.
Do you wanna
I was just gonna say, and I can't see a scenario for Citizenship Day where we'd be submitting police records anyway, because there's only very specific circumstances where immigration will ask for those, and that would be
Right.
at the day of the interview, and so I guess you'd send them with them in hand, but I would never just submit
Okay,
them unasked
thank you.
for in general.
And I guess, is part of the issue there that there might be some sort of statement in the police report
There
that
could be
is
anything.
essentially an admission to a
Yeah.
crime that's
Oh,
different
there
than the crime?
there could be
and all that
anything
stuff,
in the
yeah.
police report.
So,
Or under civil
And
tribunal.
all sorts of
Inflammatory,
interesting stuff there.
inflammatory.
So derivative citizenship, it happens, at the one I was at last year, is someone like, hey, you're a citizen, and Chris is
Really
saying you did
exciting,
too,
yeah.
yeah. So it's really cool to be
I
able
do
to do
that
that, so you always
first.
wanna make sure to ask the questions to see if they're, their parents or their grandparents, and you kind of get out the curse bands and what year were they born and how many years were over 14 and 2 years and all this stuff, and measure it out, and you might actually be able to say, you just wasted 2 hours of your life, you're a citizen already, so it's a really cool thing to be able to do. We got the charts there, though, it's as easy as it can be, and I've always thought, when I've talked to people about this, I've always said, Congress gets around to changing these rules every once in a while, and I always think of that in the past, and now I look at this Congress and they might change it again, so it's kind of interesting to see what may happen with citizenship, but you might have a person who is already a citizen. Emily? Is yours out of order too?
I've got the intake form and the attorney checklist next. Do you wanna do that?
Who should not apply? Yeah, I'll do that, but I've got, who should not apply for citizenship, is that the next
Oh.
one? Yeah, mine are a little different.
Okay, I guess we're,
Yeah, now we're gonna wing it.
all right, okay. So, and this sort of rehashes what we talked about before, that aside from the naturalization analysis, you're gonna be looking at, is the person deportable? Because obviously we don't wanna have people go forward who have removable offenses on their record. And this is just listing a couple of the deportation grounds: aggravated felony, having made a false claim to US citizenship, and this could be by means of registering to vote in some cases, having given false information to a government official to obtain an immigration benefit. This could have been at the time they were admitted to the United States, when they got their green card, so you do wanna ask them, enough information to know that there's nothing that happened in the adjustment or immigration process that's gonna cause them problems now. Because the way I like to look at it, this is immigration's final chance to review their entire record, so you really wanna maybe be asking them some questions beyond the N-400 about how they got their green card, what status they came in, did the category they came under, was that the actual category they belonged in, things like that, because this is a chance for immigration to refer someone to removal, and we've had that happen several times at our office. And let's see, if someone's been convicted of a crime of moral turpitude within 5 years of admission, so even if it's outside of the 5-year period for purposes of NATS eligibility, you wanna make sure they didn't have a crime from way back in the past that's gonna come back to haunt them now. And then again, unlawful voting can be a removal ground.
Can I just ask a quick question on that?
Sure.
I've just noticed in terms of people that we've had coming into our office that it seems in the last couple of years, CIS has been much more interested in, especially people who have gotten their green cards through marriages. and have been really in-depth looking at the marriages. And so I wonder, how, do we get into that at all, or just say, look, if it's possibly a bad faith marriage, you might wanna reconsider applying for NATS, or, you know, I don't wanna like get into the full, how did you guys meet, and, you know, question, but
Well, you know,
we just
when
have
I,
quite a few clients that
when I get
do
interested in that is if I see a really short marriage.
Right.
So, and then I might ask more about it. I mean, I guess it would also depend on if they were the petitioner or the beneficiary of that, in
I
that
guess I'm
marriage.
speaking more of beneficiaries, yeah.
Yeah.
There are also some countries that are, trigger that,
Yeah.
that thought in the lawyer's mind, unfortunately, because of immigration's sort of policies of investigating people from marriages from certain
Yeah.
countries. So, you know, the underlying immigration is, for at least the way I screen cases, a major thing, because, and I don't know if these people are even gonna be able to answer questions about it, but if there's anything wrong in there, any lie on the I-485, they will go for it. CIS will use it against them.
There's some comments in the room here about tendency to look at marriages more closely now, and
Certainly.
you know, the degree that we ask questions to the applicants about their marriage and how they got their green card. And
Yeah, so but certainly if someone's applying right, like you said, kind of right at the third year and all that stuff, there's some issues to be thinking about, so. Yeah, and it's always the interesting thing, I mean, for all of maybe an hour or so, or a little longer, that's it. You're not gonna see this person again, and you've gotta try to make some decisions, so. The disability waivers, this is slide number 23. We've discussed this before. Really, this is not an issue for us to determine. We are juris doctors, after all, not medical doctors, not psychologists, things like that. So this has to be medically determinable, and it's unable, not unwilling, but unable. So these are something we refer people out to. We have the forms for them.
all right, this is kind of going back to what Greg was talking about earlier, derivation of citizenship, and just the most recent child citizenship law, which is more generous than previous ones that went into effect in February 2001. And this sort of just lays out the elements of that. If the child's under 18, they have at least one parent who naturalizes or was born in the United States, and they are living in the physical and legal custody of that citizen parent, and they're a lawful permanent resident, then they also become a citizen when all those conditions are met. And so, you know, you may have applicants asking you, oh, will my child become a citizen when I do? And yes, if they meet all these elements, then they will. So, and I guess if, for prior laws, child citizenship laws, we'll have charts and stuff on site for if you need to check whether the person derived citizenship under a previous law.
I have no idea what slide we're gonna get to now.
On the intake form.
On the intake, couple quick things here. The forms have continued to evolve over the course of years. It's a good idea to take a look at it, but one thing we want you to know, and you want to make sure you emphasize if you can to the individuals, you're their pro bono attorney for the day. You're not their attorney to appear with the naturalization interview with them. This is a one-time only issue. We also telling people that they have to be honest with us. This is a really important issue. They have to give all the information available. We let them know that, I waive any liabilities against WNA, its staff, its agents, the consequences of my mistakes or misrepresentations. Those are issues there. And they can be contacted by WNA after this because this is through a state grant, and the state needs to have some follow-up for certain people. So it doesn't mean that they're acting as the government going out and investigating issues, but WNA will be contacting some of the people to talk to them about what was the experience like, how could it be improved, just gathering more statistical information. Chris has a question or comment.
In a later slide, you actually talk about how the attorney should be signing the N-400.
Yes.
But could you just for a second emphasize the point about you don't have to really get into the debate about the G28, but at least summarize what our current view is, the fact that it's actually up to debate still, dispute, but our only thing we can hang our hat on is that on this intake form, it says it's a limited engagement, and because if you don't have that, then you could very well be found to have been required to do a G28.
Yep.
So our only justification here is that it is just a limited engagement, and we've got to make sure that we have the supporting documentation for that.
So, and let me see if I'll capsulize what Chris said for those of you on the phone who didn't hear it or might not have heard it. But let me just be sure that in the last week and a half or so, there's been some new stuff that's come out from Immigration Service, and it talks about G28s. And I think the decision within our group and Ayla is that G28s will not be completed. Okay, that is correct. G28s will not be completed. However, when we sign the forms, we are signing our names, our firm names, if we're signing for the firm, and our firm addresses or our professional addresses. We're no longer doing what had been done in the past, which I will not mention so you don't get confused. You're signing as if you're doing this in your office as an attorney. But no G28s will be signed. And there is a big debate going on right now because we've gotten some conflicting messages, I think, over the last couple of years from Immigration Service.
But you can add that it's,
WNA.
Yeah, that's on one of the next
volunteer.
slides. It says which you
yeah,
can write
the main thing is, I just wanted to point out why it's important to make sure, for other reasons, that we sign this intake form.
You know, and it's interesting because some people, this is a terribly confusing time for a lot of individuals. They go through, they've just spent all day, in some cases, going through this, and you will have people say to you, when you're done, some people will say, am I a citizen now? It's like, no, this is the beginning. Now, you will have also said, and there's an explanation of the process, that they have to go through, you're gonna go to these other centers, send them photographs, mail it, you're gonna be fingerprinted, and you watch for appointments, but still, it's confusing, so you really wanna let people know, no, I mean, take their thanks, they appreciate it, but, I'm not going to be representing you at a naturalization interview. Attorney checklist, we've built these checklists over a course of years, and we really want, first of all, I hope that when you will see this, when the forms come to you, look over the checklist that's presented to you, because you should see, and Mari is showing it around to the group here, you should see all the right things checked, because if you haven't, someone's not doing their job right, because you may never see that paralegal again. You may never have seen the paralegal before. And you want to be sure that whoever is doing this other stuff is giving it to you complete and ready to go to the next stage. Same thing with you. You've got a lot of stuff that you've gone through. Please go through the checklist and make sure you've done things like you've checked all the post-its, you've checked for red flags, checked the criminal issues. You took the client to the handout table and gave additional relevant things. This is, again, you want to know what's at the handout table, so what you have to be able to give. And then at the bottom there, your client is ready to file today. But we're also going to have, and where's the one that says, gave client red slip if not eligible to apply. We don't want people just simply leaving your table and walking out. We want to have said and be able to prove to ourselves, we told this person not to do this, and they're going to go to the flow manager and quality control again. So these checklists are really important. They're good protections for us. And maybe we've almost overemphasized it. I don't think any of us have ever had any issues with Immigration Service or individual people bringing a claim against us for malpractice or anything like that in these things. And the local CIS office has had some very positive things to say about it. But these are all things that are being built in to try to provide the right protections for all of us.
So,
Yeah.
do you do the limited agreement first?
That's what they do when they sign in, yes.
Oh, okay.
Yeah.
No, with you
No, with
first,
us.
with the
Oh,
attorneys
okay.
first, yes,
Is
you do.
that, do you do that at the beginning of your
I
contract?
think it's a
Yeah.
good thing to do to say,
So you don't-
because they just talked to, 3 people maybe,
Yeah.
maybe 4. Hi, my name's Greg Rogers, I'm the attorney who's going to be working on this. There are a couple, I know you've gone through a lot today, there are a couple things I want to talk with you about before we start going through the form. I'm an attorney, I'm not providing services for you today, this is all volunteer. I'm not your attorney as we go forward after today, you'll never see me again, that kind of thing.
Yeah, and I mean, one of the reasons we emphasize so much the quality review and things is because we have in the past, after the fact, have heard that someone who skipped that process has had their application rejected. So we just want to make sure that that doesn't happen. So that's why we have that double check.
Few and far between.
Few and far between, but yeah.
There's even one.
But even one, yeah, we just want to make sure.
I have a quick question. I did some follow-up calls one time with Washington New Americans, and some people had their attorneys that had helped them on the day of give them their contact info, and they followed up with them, which is nice, if they had been missing some documents or something, they had contacted that attorney and had kind of followed up with them after the day of. Is is that something we're permitted to do, or is that gonna cause a problem with?
Are we permitted to give our cards if someone says, I'd like to be able to have your card, or another, and to follow up if the person's asked us to follow up? And another example, someone says, I hope you all get this experience, wow, this has really been a very good process, and I really appreciate everything you've told me. Could I have your card? I have other friends who might want immigration services, and you just kind of go, oh, so I'm gonna look at Mari and say, Mari, in terms of the following up, someone says, I've got these things, and maybe if I have questions about this, can I follow up? And you're thinking in your mind, I don't have any objection to that. As a, I imagine pro bono, when we do the legal clinics, I'm looking around at people who do legal clinic as well. When we do legal clinic, I don't think we're allowed to do kind of a follow-up. That's certainly not a paid one.
We've never had an actual policy on it. I mean, I think we've kind of discouraged it, and then, but we give the attorney referral document, because those are people who have said that they are willing to give, you know, to do representation, but.
So perhaps the better practice may be to kind of say, you know, this is kind of a one-shot deal, it is a volunteer thing, and there are the rules, you know, some people might want to be able to say, there are rules here, I'm not supposed to be giving out my card.
But if we want to,
Yeah.
we.
I think it's ultimately up to the attorney, and I think it also depends on your level of experience too. Because at least there, there are other experienced attorneys around, so.
Probably up to your level of experience as well, in terms of your experience.
But it's certainly not our policy to encourage it.
Right.
Okay.
Right.
I think that's, all right, let's kind of get into this, because now we are, right, about the time that we said we'd be done. I've got the N400 form, we're gonna kind of go through this, you've been going through this innumerable times, but the screen for eligibility and problems, complete the inaccurate, this is what we hope is all done at the end of the day. Complete an accurate N400, 2 passport style photos. When a person leaves, there is a sheet that says, here's where you can get passport photos, the closest place to where you are today, right? You can leave and get them right now. They have to have a check or money order for $595 fee, or there's a fee waiver issued, a check or money order for the 85 for the biometrics, which is a total of $680. We're gonna be making a copy of both sides of the green card, so they will walk out with a copy of it as well. In fact, they're gonna walk out with a copy of the entire packet that's already made for them. They don't have to do anything. And we're giving them certified mail things and addresses, so they will have envelopes, they will have everything they need to walk out with a copy and the packet to be able to mail. Should I just keep going anyway? Sure. Next steps for clients, a question?
Just really quick, and to understand the workflow of this, if there are people that need to go and get something, say that they do have some of the paperwork that you're asking for at their house, or they need to go and get passport photos taken, or they need to have something else run in like a money order, how is that supposed to work? I mean, if we find that out at that point when we're talking to them in the interview, we say, okay, go ahead and do it, but you have to come back before 3 o'clock or 5 o'clock, or how is that supposed to work?
The question was, what if a person does have to get additional things? So passport photo and check or money order, I don't